Well, hello everyone. I promised I'd be back, and I am back. My name is Lior Samfiru. I'm the employment lawyer. That's right, you know me. I am with Samfiru Tumarkin LLP. In fact, one of the founding partners of that firm, and I am here on YouTube, on Facebook, on Indeed, just generally on social media, live answering your calls. This is not your calls. I'm answering your questions. No calls here. This is a live session for you, for your benefits, to get your employment law questions answered. It's very simple. If you have an employment law issue, a problem, a question, maybe you've just been curious about something. Who's not curious about their legal rights in the workplace? Well, you have an opportunity right now live to get those questions answered. You type it in on the screen. You'll see a little box there. You hit enter. I'll see it. I'll read it, and I'll answer it. Again, I'm Lior Samfiru. They call me the employment lawyer. If you're in Ontario, if you're in British Columbia, if you're in Alberta, I got you. Okay, this is the time where you can get those questions answered. So take advantage of me being here for you. I can just sit here and talk about employment law all day. It's not even a problem. I would much rather you be that second voice on this live stream. You contact me right now with your questions. Give me an opportunity, not just to talk about employment law, but to help you, to make sure that you get some answers to the problems that you're having, and to get those solutions that you need to have. We have really good laws in this country when it comes to employment laws. Well, I'm here to tell you what those laws are, what they do for you. So ask the questions. Now, before we get started today answering questions, let me give you some contact information. I'm here for about 30 minutes, but after that, I get back to work. To reach me off social media, to have a private chat, private email exchange, to actually get me to help you, easy to do. All you have to do is go to employmentlawyer.ca. You see that right there, employmentlawyer.ca. Okay, that's the firm's website. You can read about employment law there if you want. Phone numbers are there. Email addresses are there. They're all there for you to connect with me and my whole team in Ontario, BC, and Alberta. But right now, I am here live with you and for you. So don't just watch. Watching is great, no problem. But ask the question, even better. I'm going to start answering questions right now. For those joining us, welcome. I'm Lior Samfiru, the employment lawyer, live answering questions. Okay. First question from H. Simple, right? I've been seeking career advancement opportunities and have been turned down for the last 2 years. Is quitting my only option? So here's the thing. Generally speaking, an employer is not legally required to advance you. They're not required to promote you. But there's a few exceptions to that. Number one is if you're being excluded from promotions or not considered for a discriminatory reason, that's illegal. And what I mean by that is you can't be excluded because of your age. Illegal. That's age discrimination. Race, ethnicity, gender, sexual orientation. Those are violations of the Human Rights Code. That's illegal. You can't do that. So if you're being excluded for improper purposes, so let's say, I don't know, let's say you're a woman and your employer is only promoting men. Well, no, guess what? Illegal. Can't do that. Big, big, big problem there. So we can talk about that. There's recourse. The other thing is this. An employer also has an obligation to act in good faith. So if they're not even willing to consider you, they're just ignoring you and marginalizing you, that could also be illegal. That could result potentially in what we call constructive dismissal. So H, for you, before you resign, never resign without talking to me first. There may actually be other recourse here, so we should talk about that, okay? But remember, anytime a company makes a decision based on discriminatory reasons, illegal, completely illegal, unacceptable. All right, great question. Thank you very much. You see how easy it is. Ask your question. I'm going to continue answering questions right now. I'm going to get to yours. You have plenty of time, so ask your question. Tara on YouTube has our next question. When am I allowed to record meetings at my workplace? So the answer to that is you can record a meeting as long as you're part of that meeting, okay? So what I mean by that is if you're speaking to someone, you can record that meeting even if they don't know about it, okay? That's fine. What you cannot do is record a meeting that you're not part of. You can't leave a recorder under the table and record two other people talking. Illegal. That's actually a criminal offense. You can't do that. But you're allowed, the law does not prevent you from recording a meeting that you are part of. All right, so that's fine if you want to do that. And in some situations, that could actually be very helpful to have that information, that recording. So thank you for that question, Tara. I'm going to continue answering questions. Those joining us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. I've been answering questions. More questions are coming in. I love it. Ask as many questions as possible. I'd love to answer 50 questions by the time I'm done today. So ask your questions. Rebel has our next question. I believe Rebel is on YouTube. Rebel says, is there a minimum amount of hours I have to get paid if it's a slow day or end early for whatever reason? It just seems hard to come into work when you know it may not be worth time. Yeah, generally speaking, that's 3 hours. Okay, you have to get paid for at least 3 hours. But again, you may have an employment agreement that guarantees you something more, in which case they have to pay you that. So the employment agreement is very important. But generally, if you kind of work shifts that fluctuate, 3 hours, if you're called into work, you have to be paid for that, even if they want you to go home earlier than that. So Rebel, hopefully that makes sense. If not, follow-up questions, not a problem. Thank you for that. All right, continuing along. Barb has a question. If I accept a remote work position, can my employer change this to have me go in office? So generally speaking, no. And what I mean by that is if the company asks you to go remote and you do that, unless there's an agreement in place that they can change their mind, unless that was the deal to begin with, they can't just change their mind. What I mean by that is that if you agree to work remote and that was it, you can assume that that's your new reality and they can't make you come back to the office. That said, okay, something I want you to consider is this. They're not allowed to make you, but they can choose to let you go if you refuse. The reason for that, a company can let you go for any reason as long as they pay you severance. So yes, they could say, well, you're not coming in, so we're going to let you go. They can do that, but they're going to have to pay you severance. What they can't do is let you go for cause because you refuse, because you're allowed to refuse. So hopefully that makes sense in that situation, Rebel. And if it's not, you know what to do. Ask a follow-up question. Or sorry, that was Barb. Ask a follow-up. Happy to answer that. All right. You see how easy it is? Lots of questions. I love it. Answer yours. You still have time. I always get questions right at the end. I don't get to them. Don't let that happen to you. You got plenty of time right now. Ask your question. Again, I'm Lior Samfiru, the employment lawyer. Thanks for joining me on this live session where I answer your employment law questions. All right, JR. JR has the next question. JR is joining us on YouTube today. I work as a house manager, but I do work not related. My contract says I will work Monday to Friday, 8:40 to 6:30 p.m. Should I get paid overtime hours after 44 hours? So if you're a manager, if you're a true manager, then unfortunately, you're exempt from overtime. So they don't have to pay you overtime unless you sign an agreement that says that they have to. But generally speaking, you're exempt if you're a manager. If you're not a manager, you have the title, but you don't manage anything, you don't manage people, then yeah, you have to get paid overtime. If you work more than 44 hours, at least that's the law in Ontario. Now, they can't get away with avoiding paying you overtime just by calling you a manager, just giving you that title. That's meaningless. But if you are a true manager, there's people that report to you, for example, then you are exempt from overtime, and the pay is the regular pay only. So, JR, hopefully that makes sense. If not, please ask a follow-up. All right. Let's see. Next question. Sam, I think you tried to ask a question, but I didn't get the question. Just as is that. Let's see. Next question comes to us from Ronald. My employer fired me when I gave my 2 weeks notice. They have not paid me for the 2 weeks and threatened to file a claim against me for damaged equipment if I try to take legal action for unpaid wages. What can I do? They had offered me a promotion earlier on the same day. Well, I mean, you're obviously owed for those 2 weeks. You can file a claim with the Ministry of Labor. You can get us to help you. And unless you damage their equipment on purpose, unless you went there and said, you know what I'm going to do? I'm going to damage that equipment. Unless that's what you did, even if it was damaged in the course of employment, they can't go after you for that. Okay? So, Ronald, you don't really have to worry about that. They owe you 2 weeks' pay. A letter from me resolves it, or you can go to the Ministry of Labor. Generally speaking, if you give that 2 weeks notice, they let you go before. They still have to pay you for the balance. Okay, so that's how that works, Ronald. Great question. Thank you for that. All right. questions coming in. I love it when questions come in. Thank you for that, guys. It's a privilege to be here with you and answer questions about employment law. So please keep those questions coming. I'm going to continue answering them. Again, I'm Lior Samfiru, the employment lawyer. Sam has a question on YouTube. If you accept a temporary layoff from an employer, does that impact your severance entitlements? Well, yes and no. So what I mean by that is if you accept the temporary layoff, well, you're not terminated, right? So there's no severance really because you're accepted that layoff. So you're only going to get severance if the company doesn't call you back to work. But on the other hand, you have the right to say, I'm not accepting that severance, but just by putting me on I'm not accepting that layoff. Just by putting me on that layoff, I can consider that to be a termination. Now you have to pay me my full severance. So if you accept that, there's no severance. There's no severance until they don't recall you back to work. So generally speaking, the problem with accepting a temporary layoff is you can sit at home for months and months and months, but it gets worse. Let's say you do get back to work, they call you back. By accepting that original temporary layoff, you've now given the company the right to do it again. So it won't be a one-time thing potentially. A company doesn't have a right to put you on a temporary layoff unless you've given them that right, by accepting it. So you have to always keep that in mind, Sam. It's definitely a big problem and a concern, I think, if you accept a temporary layoff. Okay. So Sam says that they told him he can accept a layoff from September to January or take a termination. Well, that's up to you. The problem with accepting that temporary layoff is that, number one, there's no guarantee they'll call you back in January. So the only thing you're delaying is your severance. And by accepting that layoff, you've given them the right to do it again. So let's say you go back in January, maybe in May, they decide to lay you off again and again and again. Not a good position to be in. Up to you what you want to do. If you don't accept it, you're owed your full severance. Chances are, Sam, that whatever severance the company is going to offer you is not adequate. In 90% of the cases, it's not even close. You call me. As soon as that happens, I'll make sure you get the proper severance. Again, to connect with me and my team, I've said contact me. Easy to do. employmentlawyer.ca. Again, you see that on the screen right here. employmentlawyer.ca to get my phone number, my email address, to complete a form if you prefer that. Everything, it's your one-stop shop for everything employment law, employmentlawyer.ca. So keep that in mind, Sam. Okay, Wendy has our next question. My company has decreased my hours and aren't responding to my questions about why this was done. Is there anything I can do? Yes, a company does not have a right to reduce your hours, certainly not in a significant way. So you can consider that to be a termination. We call that constructive dismissal. In other words, by the company putting you or reducing your hours, reducing your pay, you can either accept it and continue working, or you can treat that as a termination. So they don't have to give you a reason, but what you have to know, regardless of the reason, that reduction may be illegal. Okay? So two choices. You accept it, continue working, and that's it. Or you say no. By doing that, that's a constructive dismissal. I'm going to leave, and now I'm going to make you pay me my severance. If that's what you decide you want to do, Wendy, do not leave, do not quit, not until you speak to me or my team, okay? So to connect with me, again, easy, employmentlawyer.ca, again, employmentlawyer.ca. Man, today, lots of questions. I love this. This is fantastic. This makes me happy. So thank you for joining me. My name is Lior Samfiru, the employment lawyer. I'm here live answering questions. Still have time. You have time. Ask your questions, just like so many people have already. Let me answer them. All right, let's see. Ted. Welcome, Ted, from YouTube. I've been employed at the same company for 23 years. The business has just been sold. The new buyer didn't offer to continue my employment. My boss, the seller, offered me an 8-week buyout. No. 18 months is probably what you're owed, and it could be as much as 2 years, not 8 weeks. Guys, this is the example that I'm talking about. He's offered 8 weeks. He's owed 18 months, maybe 20, maybe even 24 months. So no, Ted, nonsense, ridiculous, not even close, insulting, all right? So what you need to do is you need to connect with me off air, employmentlawyer.ca, the way to do that, okay? Employmentlawyer.ca. Let's get you the severance that you're owed. You're losing your job after 23 years and the company thinks 8 weeks? Are you kidding me? Ridiculous, right? 18 months, easy, and could be more than that. So I want you to connect with me as soon as possible, and let's talk about that, and I'll help you get that 18 months. That raises another point. 8 weeks is what he was offered. I told him that he was owed at least 18 months. Well, how do you know how much severance you're owed? How do you know if that offer that you got is appropriate? Or maybe you're concerned about losing your job and you'd like to know what severance for you should be. Very easy to do. See that on the screen right now? You use our severance calculator. You go to pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. Use the severance calculator. First thing you'll see there is the severance calculator. You click on it and you answer a few questions, and it's going to tell you how much severance. 8 weeks, 16 weeks, 24 months, anything and everything in between. It's going to assess that for you. It's free. It's anonymous. Every person should use it. Over 2 million people have used it already across Canada. You do the same thing. And pocketemploymentlawyer.ca, free and anonymous, works great, takes seconds. Use that severance calculator for anyone that wants to know how much severance is owed. So Ted, now you know what to do. Reach out to me. All right, continue with questions. You have some time still. There's still, 12, 13 minutes or so on this session. Plenty of time, right? Ask your question. Give me that opportunity to answer it and to help you. That's why I'm here for. And by me, what I mean is Lior Samfiru, the employment lawyer. Okay, Carolyn. Carolyn has our next question. Another person joining us from YouTube. My employer didn't staff for the day after Labor Day and had threatened that if no one volunteers for the day, they'll arbitrarily change schedules to suit them by splitting days off, like it or not. Can this be done? It can't be done. The question is, if they do that, do you want to get into an argument and fight with them? They can't do that. They can't really punish you in that situation, but it's a question of ultimately you have to decide, is it going to cause conflict? Are you going to be comfortable with that? That's a decision you have to make, of course. All right, continuing with some more questions. Let's see. Our next question, I think, is from Lou. Yeah, Lou says, can my employer fire me for needing to take time off to deal with a family emergency? Are they allowed to require a doctor's note from me for things like this? So yes, what I mean by that is there's a leave of absence you're entitled to get, family emergency leave, where if there's a family situation and there's an immediate medical need, then you can take a leave of absence, unpaid leave of absence, but your job is protected. But to qualify for that, you have to prove that there is that medical emergency. They're not required to take your word for it, and it's not for everyone. So let's say your cousin is sick and you want to help. Unfortunately, that does not qualify you for a leave. It has to be an immediate family member. Okay, parents, children, something like that. So yes, a doctor's note can be required. Keep in mind that if you don't qualify for that leave and you decide to leave anyway, the employer may consider you to have abandoned your job. Okay, so something to keep in mind. I think hopefully most employers will be accommodating. Most employers will have some compassion if you're dealing with the family situation. But strictly speaking, it's only in those limited circumstances, and yes, with a doctor's note, that they have to give you time off. So hopefully that makes sense, Lou. Let me know if it doesn't. I'll be more than happy to follow up with you. Okay. Let's see. Next question is from Marilyn. Marilyn says, I'm still in my probation period and my employer is talking about changing my position from a managerial job to an administrative one with reduced pay. What advice would you have for me? Well, here's the thing. I mean, if they decide to change that job of yours, then even if they're not terminating your employment, you can consider that to be a termination, and then you're owed severance, potentially even if you're still in the probationary period. Okay, even then potentially. I'd have to see your employment agreement for that. But that's really it. It's not a question of stopping them. You can't physically stop your employer from doing that. It's a question of whether or not they owe you severance, and they would potentially, even in the probationary period. They would definitely owe you severance if it's outside of the probationary period, if you've already gone beyond that. and they decided to demote you from a manager to an administrative role, 100%, that's a constructive dismissal. You're owed severance. You don't have to accept it. You can leave with that severance, but potentially even the probationary period. So the best advice is send me a copy of that employment agreement. Okay, let me see that. And once I see it, I'll be able to tell you what it does and do you still get severance in the probationary period. To connect with me and my team, to send me a copy of that employment agreement, you can do all that through employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen right now. Use it. It's your first resource. You have an employment issue. Your boss did something, said something. You're being threatened. They've given an ultimatum. Just grab your smartphone. Go to employmentlawyer.ca. You can probably already find answers there to your questions. You can ask questions there. You can connect with me and my team. Everything you need is right there. You have that power now. Just by having your phone with you, your desktop at home, whatever it is, you can go to employmentlawyer.ca. You are now taken care of. Okay, let's see. JR had a follow-up, says, should my pay stub show they are paying me overtime? Yes, if you received overtime, then that should show up on your pay stub. And if it doesn't, you have to talk to your employer and find out what's going on there. Simply Unkind on YouTube. Unkeen? I don't know. I was fired from my job without cause after 15 months of service. I worked overtime daily and dealt with workplace harassment consistently. What are my rights? So certainly, even after 15 months, you're owed severance. In fact, I don't know how old you are, and I don't know the type of job, but you could easily be looking at 6 months severance, potentially even more, depending on a few factors. Now, that severance has to include your overtime. So, for example, let's say on average you earned $100 a week in overtime. I just made up a number. Well, then that has to be accounted for in your severance. They have to add that to your severance. So if you're getting 6 months of severance, that should include the overtime you would have expected to earn. Now, in terms of the harassment, the question is, was it what I call discriminatory harassment, where you harass because of your age, your ethnicity, your place of origin, etc.? If you were, that's a human rights violation. Okay, it's illegal. That you could be owed additional damages. That's very, very wrong, very illegal. If the harassment was just someone being a jerk, there's not much that you can do about it once you're no longer there. Okay, you can do something about it once you're there, but once you're no longer there, not a lot. But for you, let's make sure you get that severance. I can almost guarantee you that the company offered you after 15 months a lot less. So let's see, if I have to guess, 3 weeks is what they offered you. And keep in mind, it should be probably closer to 6 months, maybe even more than that. So that's why you need to connect with me through employmentlawyer.ca to make sure that you get everything that you're owed. And you see that address, employmentlawyer.ca. I'll repeat that again and always, because it's that important that you go there if you have an employment law issue. So let's see. Next question. Guys, you still have like 5 minutes to go. That's plenty of time to still get in the question under the wire and get me to answer it. All right, so let's do that. Let's make sure I get your question right now. I'm still live. I haven't turned off my computer yet, so let's do this, all right? And again, for those joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Okay, with that said, Helen 2006 has a question. Can your lawyer work together if going to court? I'm not sure what that means. Your lawyers may have different attributes. Don't know what you mean. Sorry, I don't understand the question, Helen. Again, if you have any questions, please ask right now. Let me tell you something else that you may not have known when it comes to severance. And that is that there's a bunch of factors that go into figuring out how much severance you're owed. So the biggest factors, you'll hear me talk about that, is your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. So those are kind of the big factors. But there's a bunch of other factors that can impact your severance. For example, your medical condition. If you have a medical condition or a disability, it's going to mean more severance because it's going to be harder to find another job. The industry you work in, if you work for an industry that has a lot of jobs open or one that doesn't have a lot of jobs, again, that can impact your severance. The economy, state of the economy. Is the unemployment rate high or low? The higher the unemployment rate, the more severance you get. So you get the idea. There's a lot of factors that can go in. Whether you're recruited from another job, that could be a massive factor. So there's a ton of factors that impact how much severance you're owed. That's why it's so important to get that advice so we can assess properly. So many people believe, oh, it's a week per year of service, it's 2 weeks per year of service. No, nonsense, not even close. Okay, don't believe that myth. That's all it is. It's myth. It's wrong. It's false. To connect with me and my team, again, employmentlawyer.ca, or use our severance calculator, pocketemploymentlawyer.ca. All right, let's see if we can get a couple more questions in under the wire. Andy has our next question. Can an employer force you to pay out of pocket for stolen items if they have already received an insurance payment for it? I was not responsible for these missing items, but was working when they were reported stolen. Well, even if they didn't get insurance payout, they cannot force you to pay for them. Okay? It is part of a job. Unless you did something horrible, it's part of a job. These things are going to happen. Okay, and that's kind of the employer's loss, the employer's cost. They can't ask you to pay for it. So you can say no. And if they've already gotten paid with the insurance company, well, now they're just being greedy. So no, they cannot ask you or demand or threaten you or fire you for refusing to pay for something that happened in the course of business. Okay. Let's see. Next question. Maybe it could end up being our last question today. From Sam on YouTube. What is the best way for a company to either confirm or deny a record of employment existed, especially if a said worker is interested in receiving a reference check? So a record of employment is only relevant for the purposes of EI. So EI or Service Canada should have a record of that document. So I'm not sure what you're asking in terms of a reference. If you have someone that you work for and they're okay with being a reference for you, you can give their name. And that's fine. But you have to talk to them to make sure they're okay with it. There's nothing to do with a record of employment. If you have a former boss, a manager, a colleague that's willing to be a reference, that's great. Give them their number and they could be that reference check for you. Hopefully that makes sense. So let's see if we can get another question. And JR says, how long after I leave a job can I ask for unpaid wages? So 2 years from when the wages were owed. Okay, so 2 years from if they should have paid you a year and a half ago, you're fine. If they should have paid you 2.5 years ago, you're not fine. There's a 2-year limitation period. So Alessandra will have our last question today. Do you have any tips about how much to sue for? For example, let's say I've been working for an employer for 5 years and a lot happened. More recently, they changed your role. Just go for dismissal? Well, no. You have to get legal advice. If you're going to try to do this on your own, you're not going to be able to do it. There's a lot to assess here. So to ask me how much I should sue for it's like saying if your car is broken, coming on here and saying, what's wrong with my car? Well, I have to see your car. I have to assess your matter, and I have to fix your car, right? And the reality is if you don't know what to claim for, you're not going to be able to get it. So Alessandra, I think you're going down potentially a wrong path. You need to call us or email us and let us do what we do, which is assess what you're owed and get you everything you're owed. And by the way, if we do our job right, you may not have to sue at all. Okay, we can get it without even having to do that. So that's why you contact the experts. You reach me and my team through employmentlawyer.ca. That's a good note to end it on. Guys, thank you so much for joining me. Again, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Always a privilege to come here and answer your questions. I love being able to answer them. I'm going to turn off my computer now, or at least my camera, but I'm getting back to work. So if you want to talk to me, you want to exchange emails today even, not a problem, employmentlawyer.ca, the place to do that. And I'll be happy to connect with you. I'll be back next week as well. Don't wait until then. If you need to reach me, employmentlawyer.ca. Thank you, everyone. Have a wonderful day.